This couple let their newborn baby die from a curable condition because of their religious beliefs. This is a shocking case. The child was just 61 hours old. And even though they were told to take their baby to a doctor, these parents didn't. Instead of calling 911, they prayed the condition would go away. This pair was convicted of murder for what they didn't do for their newborn, and they just learned their fate this week. And what may shock you even more, the couple seems to still not believe what they did was wrong. And they say they would never take a child to the hospital, even if it could have saved her life. We're on the case, presented by Law&Crime. I'm Chris Stewart. This is a story about faith, medicine, and the law. And all three collided in a courtroom in Michigan. I want you to meet the Piland family. That is the dad, Josh, and the mom, Rachel. This couple lived near Lansing, Michigan. Joshua used to serve in the Marines. On LinkedIn, he wrote, that's where he learned the value of good character. Josh's wife was Rachel. The two seem to spend a lot of time with their children. There's pictures of the family out and about in Michigan exploring the outdoors. On August 29th, 2016, Rachel made a big announcement on Facebook that they were going to become a family of 5. We have a due date adjustment, she wrote. Baby number 3 is due on February 6th, 2017. All glory to the Lord for another healthy baby, she wrote. Joshua and Rachel were very much into their faith, and you'll see that as this story goes on. This is a picture of Josh in 2012 being baptized in a pool. He and Rachel also posted Bible verses regularly on social media. Faith is an important part to this story. This couple said they were expecting the birth of their 3rd child on February 6th, 2017, and here's a picture of that baby. Abigail Jean, she was born on her due date. But days later, Josh took to LinkedIn and wrote that, quote, our daughter Abigail Jean passed away last Thursday morning. We are standing in faith for her resurrection according to the word of God. You can see several people posted comments saying that the Piland family was in their thoughts, and Josh responded thanking people for their prayers. But Josh didn't say how his newborn baby died. That baby was just over 60 hours old. That's less than 3 days. Young Abigail was born in the Piland's home with the midwife helping on her due date, February 6th. Now that midwife noticed that Rachel's newborn was jaundiced. It's not uncommon. Babies can have a yellowish skin tone, and it's the result of bilirubin levels being high, the baby's liver not developing, being able to handle that bilirubin yet, and it can lead to issues like brain damage down the line if it's not treated. The midwife, though, said that Rachel brushed it off. Rachel's mom even said that the baby should be taken to the hospital. She was there for the birth as well, but Rachel declined, citing the couple's religious beliefs. According to the Michigan Free Press, when the midwife told Rachel that her child was going to die, Rachel said, quote, God makes no mistakes. Instead of calling 911, the Pilands prayed over their child's body. Abigail was only alive for less than 3 days. Her death, medical experts say, was preventable, but her parents did nothing. The authorities found out about what had happened because Rachel's brother, who lives in California, called police in Michigan. Initially, Joshua and Rachel were charged with manslaughter, but those charges were later upgraded to a charge of murder as detectives learned more about the Pilands, their beliefs, and their belief in the power of prayer instead of seeking medical treatment. Even facing decades in prison, the Pilands both took the stand in their defense at their trial. Now, they didn't seem to appear to believe that what happened was their responsibility or wrong. Rachel said on the stand, quote, we believed praying was the best thing we could possibly do for her. Even if she had died from some kind of struggle, we wouldn't have called 911. Josh also took the stand, and here's part of what he said per the Lansing State Journal.
You don't know anything about what jaundice is and how severe it could be to your child, correct?
I don't argue with that.
You're going to rely on the professional who you hired to attend the birth to inform you about these things, correct, sir?
I'll rely on my creator who created us.
And you're also going to rely on the professional, right, sir, that you hired to attend the birth of your daughter, Abigail, the trained professional, right?
We hired our trained professional for baby catching. We rely on the Lord for all healing.
Defense attorneys tried to argue that the couple did something to save Abigail. They put her by a window. Sunlight can help with those bilirubin levels and be a treatment for jaundice. Before I get back to the trial, I should also tell you this. The next year after Abigail's death, the couple had another baby. It was a girl they named Verity. Within hours, though, of her birth, an anonymous tip was made to Child Protective Services, who took that baby into their care and away from the Pilands. Verity was taken to a hospital where she was diagnosed as significantly jaundiced, and she needed a blood transfusion, in fact, more than one. The Lansing State Journal wrote, though, she was doing well after those procedures. The care that Verity received was the kind of care that the Pilands did not allow her sister Abigail to get in her short life. In March of this year, the Pilands were convicted of murder, and just this past week they were sentenced. At the sentencing, Rachel's mom spoke and made it seem that Josh's religious teachings cut Rachel off from her family. Here's part of what she said per the Lansing State Journal to her daughter.
Is that what you interpret Christianity to be? Becoming an island unto yourself?
Her mom also said, with her daughter set to spend decades in prison, that the courtroom and those moments you just witnessed there could be the last that they ever have speaking face to face. On the stand, before the judge gave her a sentence, Rachel stood by her religious beliefs, seemingly not taking fault for not allowing her daughter a shot at recovery from a curable disease by saying, "My husband and I believe the very best thing we can do is seek healing from Jesus Christ." The couple also was active on social media in the days leading up to their conviction. They posted Bible verses almost daily on their Facebook page. But this week, the judge sentenced both of them to a minimum 20 years in prison for the death of their daughter, Abigail. Joining us now from Michigan to talk about this case is criminal defense attorney Wade Fink. Thank you for taking the time to be with us on Law and Crime. What does the law say when it comes to a parent's decision of care for their child, especially when it comes to religion?
You know, it's a good question, Chris, and this has long-standing roots in our law and jurisprudence over many decades and centuries, actually, back to vaccination efforts back in the 1800s. But the lay of the land is basically that where religious freedom abuts putting children in danger or neglecting children, then parental rights, so to speak, or even if legitimately held religious beliefs put a child in danger by community standards, then the state has a right to regulate that. The community has a right to say what is appropriate conduct and what is not in those circumstances. And really that comes from the idea that, a parents can make a decision for themselves about their medical care, about numerous different things, that a child who's not fully grown, not fully developed, does not have the same rational decision makings that a parent does, can't make that decision for themselves. So the community and so the state has a right to kind of set what is appropriate for a parent to decide or not decide based on what their beliefs are.
Because in this case, it was a baby, Abigail. She had a jaundice, which is not particularly uncommon in babies, and it's a trip to the hospital can save a child's life from that condition and make it very minor. In this case, this couple was originally charged with manslaughter, and then it's upgraded to murder. Why would that upgrade? What about this case stands out to you as to why those charges needed to be at that level?
That's a great question and a particularly unique thing about this case because, the majority, at least in my own research on this, the majority of cases that fall into this category generally get charged as manslaughter. The tragedies that occur in these situations usually have an intent element lacking because, as you asked, that's the difference between the murder charge, second-degree murder, which requires a specific intent to kill, or creating a situation that is so reckless, that is so indifferent to the human life that you essentially intended to kill someone. That's the difference between murder and manslaughter, which is more of a gross negligence standard without the intent to kill. So I think it's very unique and telling that the prosecutors viewed this case as so indifferent, so extremely reckless by these parents, this decision, that it amounted to an intentional homicide. And the jury bought into that despite the arguments to the contrary.
Right, because I know as a defense attorney, I mean, how would you have defended this case? Because, listen, I mean, this couple, they could have very easily brought this baby to the hospital and hopefully her life would have been saved. But also, I mean, they do seem authentic in their religious beliefs, agree or disagree with them, where how do you prove that they were trying to kill their child as opposed to just being tied up way too much in their religious beliefs?
Another great question, Chris. And from what I can tell, as the outside observer who wasn't involved in the case, this was defended the way that I probably think it was the best route. And essentially what the defense said through the testimony of not only their clients, but the surrounding circumstances. I believe they used the example that the parents at one point put the baby by a window to allow sunlight, which can be a treatment for jaundice and extreme circumstances. They tried to present the situation for what you just said, Chris, which is this was a legitimately held, deeply, believed religious decision that was made by the parents. And that can't form an intent then to kill. What I would say to myself in making that argument, which I think is the best one you can, that because this is a true belief, it can't be intentional. And what I think this case really comes down to, it's such a tragedy, is the extreme indifference. Because when you are a parent and when you take on the responsibility for another life, you cannot act with the selfishness that these two parents acted with, at least by the evidence as I've seen it. And we've seen that in other cases, in the Oxford case, the Oxford shooting, and many other parents who make decisions that chiefly are about themselves. That child does not get to make a decision as a baby, an infant, on whether or not it's going to seek medical treatment for a very curable disease that we know what causes it by science, and doctors know how to cure it. So if you want to be a martyr yourself, that's one thing. But the law does not allow you to make a martyr of your child who doesn't get to make those decisions. And your extreme beliefs, whether you deeply, truly have them or not, have to give way to a general sense of what's right. And here, I think it's on that element, the extreme indifference to the child's life and what they don't have the ability to choose, which is to get medical care. So I guess all in all, what I'm saying, Chris, is I would have defended it similarly, but I think that where this case, rose or fell, was on the idea that they created a situation that was so indifferent to whether the child would live or die that it amounts to murder. That's also a form of second-degree murder.
And, this is a story that I think from our perspective, and we're talking about the law, we're not talking about, whether someone should be into their faith or not, but that is part of the story and how this potentially could have played to a jury. When you have a client who is so forward with their faith like these were, how do you as a defense attorney handle that and how they could come off to a jury? And how do you control that in a courtroom?
This is extremely common. Another great question, Chris, because it not only comes up in the context of religious beliefs, but just whatever deeply held conviction that clients have. I think it's probably one of the biggest challenges I have as a criminal defense attorney is the deeply held convictions, whether they're religious or other, that my clients may have that I may not see as in their best interest. So, in this case, look, we are advocates for our clients. We are there to make sure that not only do they get a fair trial and a fair shake, but we're kind of the guiding hand through the legal system to through its avoid pitfalls and things that a client may not otherwise know on their own. But at the end of the day, it's their story. And as long as you feel your client is competent and understands your advice and they're eyes wide open about the decisions they're making, they take your counsel as to how you think it's going to play out, then I feel that I've done my duty. If I need to share their story that I don't necessarily think is the best strategy, sometimes I will, make them feel as though they're heard, and their story will come out through the best advocacy I can do. If I think it's an objectionable, unethical, illegal defense or something of that nature, of course, then it becomes the lawyer's duty to strategize and make decisions in their best interest. But generally speaking, to your question, I run up against deeply held convictions that I think are either wrong for one reason or another, not the least of which, legally speaking, or to a jury, has very little chance of success. And you try to counsel, and sometimes clients come to their senses and understand that your strategy and come to agree with it. Other times you butt heads, and that's a very challenging part of criminal defense work. And I can imagine reading about this case and viewing it from an outside perspective that this was a major challenge for the defense attorneys.
Yeah, because when Josh Piland took the stand, there was a clip that I watched, and if I was a juror, I was sitting there being like, this guy's just talking about himself. Like, he was talking about his religious beliefs. He was talking about, even if you agree with his religious beliefs, he was just talking about himself the entire time and talking to the prosecutor. And as a juror, I would have sat there and said, like, this guy just doesn't get it. When it comes to the decision of whether or not your client is going to take the stand, especially in this case where it seems that he has such deep convictions, I mean, what is the conversation like, and how much control do you have as the defense attorney who wants to win a case or at least defend your client to the best of your ability? What is the conversation like ahead of that?
So there are very few things, I shouldn't say very few, there are a handful of things, if not a few, an extra handful, that are solely client decisions. In other words, no matter whether the lawyer agrees or disagrees, they're up to the client. One of those is their right to testify or not testify. So strategically, how I feel about something can be overridden by the client in that circumstances. And there's a few others, whether to plead guilty and a few other things that clients solely control. In a case like this, if I knew the testimony was going to be what it was, so self-serving, and it's precisely what I said earlier, that about why making decisions about yourself is one thing, but for others, based on your self-proclaimed religious beliefs that are okay for you. If I knew that that's how it was going to come out, it obviously would have been my counsel not to testify. I've with clients who have insisted upon testifying that I didn't think should. I'll do mock cross-examinations to show them how it's going to come out and try to shed some light and open their eyes as to why my strategy is what it is. In this particular case, there was probably a debate amongst the defense attorneys on what to do, because you needed to show the sincerity of the defendant's belief in order to cut against the second-degree murder charge. That's the whole idea. We're showing this religious belief is so sincerely believed, they couldn't have intended to kill. Maybe it was manslaughter, but it certainly wasn't an intentional homicide. So they needed that evidence in there, and whether they could have got that through other testimony or the prosecution witnesses, I don't know the answer to that. But generally speaking, it is a very difficult conversation with some clients. Some clients, they'll get it on why they can't testify. And people, I'm always going to remind you, don't mean to go off course, Chris, but very important. As if you're a juror or if you're observing the criminal justice system, there are very good reasons that a defense attorney may not put a client on the stand, and it doesn't just mean they're guilty. There are a lot of reasons that you would do that that don't necessarily mean they're guilty. So I always try to remind my future jurors out there watching that there's a lot of reasons we don't put defendants on the stand necessarily.
No, that's a good point to make, and we always welcome that because we all get the jury summons in the mail, so it's a good thing to remember before we head to court. This couple both received a minimum of 20 years, and I believe it was between 20 and 40 they'll spend in prison. So they would be out in their elderly years, but they still have the opportunity to have some life once they get out, and their daughter didn't get an opportunity to live longer than 3 days. In Michigan, typically, if you are convicted of a crime like this, second-degree murder as they are, what do you make of that sentence from the judge?
I've been in front of Judge Jamo before. He is a very thoughtful, reasonable jurist. He will, hear you out on your sentencing arguments as to what mitigates or what aggravates a situation if you're the prosecutor. I think he's a very thoughtful man, and I've been in front of him on some tough issues. So I will say that I don't think his sentence was cursory or without a deep analysis. Generally speaking, in crime, second-degree murder, first-degree murder is easy in Michigan, as it is in most states. It's life without parole, period. Second degree, it is a common sentence to be anywhere from 17, 18 years to very aggravated murders that have particularly bad elements about them, torture or kidnapping or something like that. It could be up to life. So it's not unheard of to have a second-degree murder sentence that would be 30 or 40 years plus. But 20 is within the range of a general conviction for murder. I don't think this is outside the bounds, particularly high, particularly low. And this is a particularly tragic case of such an innocent, beautiful child who had absolutely no ability to make any autonomous choices for herself and fell subject to what I view the deeply selfish decisions of her parents. So I don't think that this doesn't raise, as an appellate lawyer who's had a lot of success in Michigan, this does not get me excited about the prospects of an appeal on the sentence. I think that is a rational view and within the guidelines of what was probably prescribed.
And then just lastly, kind of thinking of Michigan, and I think of this case, and then you brought up the Oxford one with the Crumleys, and we've seen cases, obviously a very different type of case involving a shooting at a high school, but you see parents now being held accountable in whether it's a mass shooting case. I think here in Georgia, we had the case with the Grays and Winder. And in this case, you have parents of a different kind being held accountable. Have you seen the legal system in Michigan start to hold parents more accountable than maybe they have in the past?
I've been asked that question, especially on the Crumley case. I've been asked that question a lot in the context of a slippery slope, right? If we aren't careful about guarding, parental autonomy and the individual nature of parenting and being responsible for your children's decisions, if you're in the Oxford case and things like that, that it's a slippery slope that parents become held responsible for things they shouldn't be. I have not seen that as the answer to the question. And I've always, even as a criminal defense attorney who has a much different view than prosecutors and law enforcement, I still am very hesitant to see the slippery slope argument, because I think these cases, the reason you're covering it, Chris, and the reason the Crumley case was so unique and the parents being charged, they're unique because they're unique. They're unique because the conduct is so either tragic or evil in some circumstances that it warrants the type of responsibility and accountability that gets laid on the parents. So no, I don't see this as like a slippery slope into an unlawful intrusion into religious decisions. I can see why that would be spun maybe politically or otherwise into vaccine mandates and things that are hot topics as to what's next. But the answer is I haven't seen that. And I would caution people that these are particularly egregious cases where juries, these defendants got their full due process rights. Jurors of their peers heard their cases. Judges heard their cases. Appellate judges heard their cases. And so far have been held to account.
Yeah, it's a unique case, very sad case out of the state of Michigan. Wade Fink, criminal defense attorney. Thanks for coming on Law and Crime. We appreciate it.
I appreciate you guys. Thank you.
That will do it for On the Case, presented by Law and Crime. Subscribe to us on YouTube and Spotify. I'm Chris Stewart. We'll see you next time.